This public interest litigation concerns setting up of crematoria to cremate the indigenous Khasi and Jaintia and Hindu deceased. Full stop. Their rites and rituals accompanying the funeral are different. But the procedure for disposing of the dead body is the same, by cremation. Full stop. The Khasi and Jaintia, the indigenous Khasi and Jaintia people are reluctant to share a crematorium with the Hindus. Paragraph. The problem is lack of crematoria lack of adequate number of crematoria in a large area of the state, as a result of which dead bodies have to be carried a long distance to be cremated. Paragraph. In this public interest litigation, directed at in the order dated 25th October 2024, in this public interest litigation, we tried to resolve this problem by asking the amicus curiae and the district magistrate to sit with the two communities, and convince them to agree to their dead bodies being cremated in one crematorium with different timings for cremation of members of different communities, if the need so arose. Paragraph. In the said order, we also noted that the government had proposal to set up new electric hybrid crematoria in New Shillong, Tura, Jawai and Nongpo, and sanctioned or completed projects at Silai, Ayaukin, Nongstoin, Helish, Kirshi Village, Jawai, West Chandia Hills and Jhalupura in Shillong. Mr. Lam, you will get it all in the previous order. Paragraph. Apparently, till now, little or no progress has been made. The learned amicus curiae, who is also the Deputy Solicitor General, placed before this court for discharge. Paragraph. Accordingly, we discharge him and appoint Mr. So-and-so as amicus curiae on the same terms and conditions, including honorarium, with effect from today. Paragraph. Who is appearing for the state?
Lordship,
What the district magistrate has done?
Lordship, I have to seek instructions regards to that, Lordship.
Done nothing.
Lordship, I haven't received instructions yet, Lordship. If I can get a few more days, Lordship, I'll get the instructions.
Paragraph. There is no report in court as to any progress made. Full stop. Paragraph. We are not at all pleased with this state of affairs. Full stop. We direct the district magistrate to immediately comply with our order within 4 weeks from date. Full stop. The newly appointed learned amicus curiae shall collaborate with the district magistrate in terms of our order dated 25th October 2024. Let a copy of this order be transmitted by the Registrar General of this court. This order is there. Page 2. Page 3. Page 3. 50,000 per month. You have received the honorarium.
No, my lord. And I'll waive that, my lord. I'll waive that one. Yes, sir. As for my part, my lord, the new amicus may be paid, my lord.
Let a copy of this order be transmitted by the Registrar General to the Chief Secretary of the State. List this public interest litigation on April 8th. The district magistrate and the amicus curiae are to file a joint report.
Deeply.
Item number 2.
Yes.
My lord, affidavit has been filed on behalf of the institute, my lord. And if my lord will see the affidavit, my lord, as per the affidavit, my lord, the institute doesn't seem to have any problem, my lord. If they go ahead with the IVF treatment.
Who is appearing for the institute? Yes, what do you have to say?
Because of the bar created under the 21G.
Sorry?
Because of the bar created under 21G.
Yes, that we know. Above 50 years of age.
Only because of that, my lord, we are not in a position to. If your lordship will die.
No, how can we direct against the statute?
That is the. My lord, that's why we are.
Is there any precedent of any court directing?
My lord, there are in many cases, my lord, direction was given.
Then you file a response to this affidavit,
My lord,
and you argue the matter.
my lord.
May I submit, Your Lordship?
Yes.
Lordship, in fact, Your Lordship, I have come across a judgment of the Honorable Kerala High Court, Your Lordship, affirming the constitutional validity of Section 21G, and it is also recorded in the judgment, Your Lordship. If Lordship is pleased to. If Lordship kindly come to internal page 11 of that judgment, at paragraph 19, Your Lordship.
Page?
Page 11, Your Lordship.
Para 19.
19, Your Lordship. We also notice may I read it, Your Lordship?
These Karnataka, Calcutta, and Delhi High Court orders were interim orders.
Lordship, Lordship, it appears that 19, this
Page 12.
page 12, Your Lordship, the interim was content in writing the way below also can be printed. However, as already found out, insofar as the provision of Section 21G of the Act have been upheld by this court, as concerned, we see no reason to permit the officer service in that case also. We are not called upon to consider in the present case where one of the parties is below the prescribed age and the active services are sought for from a donor host. We also noticed that the Apex Court is considering the very same issue and no interim order have been issued in the matter. Your Lordship, so far that matter before the Honorable Supreme Court, Your Lordship, I have tried to get it, Your Lordship.
You are appearing for the hospital.
Lordship, I'm appearing for the state, Your Lordship. I'm just bringing to, because I've come across, Your Lordship, this, if Lordship kindly see the order. And the last order, Your Lordship, appears that 11/2/2025, Your Lordship, the matter will come on 24/3/2025. On this section. Okay, once already, we'll try to get all this statement here.
Well, 11th February is heard, made the following order.
Lordship, yes.
Where is the order?
That is the order.
List on so and so.
Lordship, Lordship, if that order, this is the order dated 7/1/25, Your Lordship, it just say we have heard learned senior counsel, learned assistant solicitor general, and learned counsel for their respective parties. It was submitted that interim this abyss, the age bar and the process will be commenced prior to the enforcement of the Act, regulation, and rule may be taken up for consideration at the first instance. List the matter on 11/2. Then Lordship kindly.
Nothing has happened on 11/2.
Lordship, it on 11/2, you just order to say that list on 24/3/2025. If Lordship, if this matter can be taken up on some other day, we'll try to find out all this order from the Kerala, from the Honorable Kerala.
No, I was reading the thing, judgment in AIR Calcutta, single bench judgment, reported, I think, February or January, December, like that, on this itself. I just seen it, I have not read it. But this of the Kerala High Court refers to the Calcutta judgment. There is also Karnataka and Delhi judgment.
Yes.
But their lordship say that it is an interim order permitting the procedure.
Lordship,
And
because
the final thing is still pending.
it has been reported in the predictum also, Your Lordship. I've come across that in predictum also. In that legal app, Your Lordship, in predictum. I've come across also. I've read that.
Calcutta judgment.
No, Your Lordship, the order from the Honorable Supreme Court, Your Lordship, but I could not get it, that order, Your Lordship.
Kolkata High Court, my lord, has allowed in one of the case, my lord, Saswati Mahuri. That case, my lord.
Reported in AIR.
My lord, I do not have the AR citation, my lord.
Lordship will try to find out.
Judgment.
My lord, I have referred in my repetition, my lord.
My lord, as far as Kerala High Court, my lord,
But,
the division bench is state the orders.
This is Kolkata.
There has been stayed, Your Lordship.
We have annexed the order in our affidavit.
Lordship kindly come that Kerala judgment, Your Lordship kindly come to para 20 again, Your Lordship, please, at page 12, Your Lordship. Lordship will say like this: though the High Court of Karnataka, Calcutta at Delhi have issued order permitting the continuance of treatment, we notice that as regard order issued by the Delhi and Karnataka High Courts, the issue was with respect to the amendment under the Surrogacy Regulation Act 21. As regard the orders issued by the Calcutta High Court, maybe the one which Lordship has spoken to, the constitutional validity of the ART Act is being considered, and only an interim arrangement has been made in the matter. However, for the reasons stated here and above, we are clear that unless the provision are declared as of, no direction can be issued to the authorities to the contrary to the provision respective. So, Your Lordship, maybe Your Lordship, the Honorable Kerala High Court
State the order, so the single judgment.
the order of the learned signature has been stated by this judgment, Your Lordship. You haven't closed this meeting, or you have events? You haven't cleared. Para 11, no? I think this is relevant. Para 11. Yeah. See?
You also consider this affidavit fee.
Maybe.
Government.
My lord, may I refer to the affidavit of the union, my lord?
Their affidavit, human, page 77. This affidavit.
Affidavit of Union of India, response number 1. There are 5 men. So there is para 10 also.
Yeah. Listen to her.
What is exactly this procedure?
My lord, here, my lord, in my writ petition, I have collected some information, and my lord, I have explained,
You come to the Calcutta High Court order.
my lord. Here, my lord, Calcutta High Court, in page number 17, that order, in page number 17 of the judgment, my lord, paragraph 2. It says, my lord,
No, is there a preliminary procedure also?
my,
You come to page 18, the interim relief is, we are considering the writ, but the preliminary steps may be taken. Do you have copies of this judgment?
my lord,
What preparation you make for matters?
my lord, this is the copy of the judgment, my lord. I downloaded from internet, my lord.
Downloaded for you. Have you made one for my lord?
My lord, I have a copy, my lord.
Please give it to my lord. An unreported judgment you should give your adversary also.
If I can read, my lord, page number 17, paragraph 2 onwards. my lord.
Page 16 onwards, 16 last paragraph.
I'll read from paragraph 6, last paragraph from page number 16 only, my lord.
Yes.
The narration of the above chain of events would show that the petitioner number 1, wife, was 42 years old, and the petitioner number 2 was 52 years when they first visited the fertility clinic in 2019. Therefore, the petitioner number 2 Act, which prescribes a age cap of 55 years. Petitioner number 2 crossed the upper age limit of 55 years only recently and is now 56 years old. The questions of giving any kind of interim relief to the petitioner will become more of a challenge with each passing day, as the ineligibility of the petitioner number 2 would increase with a possible delay in the adjudication of the present writ petition. Simply put, the petitioners cannot afford to wait for availing of ART service until the final adjudication on the virus of the Act of 2021. This court is therefore of the view that the petitioner number 2, as the male counterpart of the commissioning couple and having crossed the prescribed age by just a year, has established a case for interim relief. This court is alive to the fact that grant of interim relief may amount to final relief in the present facts. However, such an apprehensions would be allayed on the ground that the ultimate relief claim is for declaring Section 21G of the Act as ultra vires, Article 14 and 21 of the Constitutions. The interim order is only in aid of the final relief, and in consideration that time is of the essence in the matter. The petitioners may not be in a position to sustain a long-drawn litigations on purely psychological constraints. There is hence every reason to consider their prayer for interim relief in the light of the peculiar attending factors which have been brought to the attention of the court. Thus, the material placed before the court and the balance of convenience unmistakably shows that the petitioner had made out a case for interim relief. The preparation for assisted reproductive technology should be permitted to start, as further delay may frustrate the petitioner's long-standing wish to have a child. There shall accordingly be an interim order permitting collections of sperm of the petitioner number 2 for preparation of the embryo with a donor egg. The embryo shall be preserved till disposal of the writ petition. The direction is given on Dr. Sivili Mukherjee of the Fertility Center mentioned in paragraph 13 of the writ petitions. My lord, here,
Donor egg means what? It is of a different person.
no,
the
the
wife.
husband and wife, my lord.
It is fertilized and then inserted.
Inserted, my lord, in the women's uterus, my lord. Here, my lord, I have in my petition also, my lord, I have mentioned the petitioner seeks to avail the IVF treatment, a medically recognized procedure for assisted reproduction. The IVF is a process where an egg is combined with sperm outside the body and the resulting embryo is transferred to the uterus. This technique helps
Which
overcome.
page?
My lord, it is also in the synopsis, my lord, the page number B. In the synopsis also, my lord, it is there. Page number B.
From where are you reading? From the judgment?
No, my lord, from my petition, my lord.
How old is your client?
She is just crossed 50, my lord.
No, 50 means how much?
Her date of birth, my lord. That is 21st February 1974, my lord, her date of birth. She was 50 years, 9 months when the application was filed, my lord.
Let the preliminary things be done subject to decide. Like taking the embryo and putting it. And insertion is high risk. They are saying that we will decide. No, the age factor will be considered when it is inserted, that is high risk. Yes, when it is being fertilized, then there will be no, it is outside the system.
It might be probably.
No, outside the system, it is this interim order has permitted. Same interim order, right? And we will keep it up for 2 weeks, not much, up to 2 weeks. When was she born?
Page number 4.
Are page number, give the date.
She was she was born on 21st February 1974, my lord.
Yes. The writ petitioner was born on 24th February,
21st, my lord.
21st February, 1974. Full stop. She is 50 years.
9 months, my lord, at the time of filing this.
Now
Now she's just 51 years, my lord.
just over 51 years of age. Full stop. At the time of filing of the writ petition, she was 50 years, 9 months old. Paragraph. She challenges section 21 bracket G bracket I of the Assisted Reproductive Technology bracket Regulation Act 2021. Full stop. It lays down that an art clinic, ART, can extend art services to a woman above the age of 21 years and below the age of 50 years. What is IVF?
In vitro fertilization. my lord.
Fertilization.
In those circumstances, The Institute of Human Reproduction, IHR, all capital, a unit of Goenka Nursing Home Private Limited, Guwahati, refused to perform IVF. What is the full form?
In vitro fertilization.
In vitro fertilization bracket IVF on the writ petitioner. Paragraph. Hence, this writ by our earlier interim order, we had asked the Institute to file a report prepared by an expert body as to the feasibility and risk involved in performing the procedure on the petitioner. Today, an affidavit affirmed on 26 February 2025 by the director of the institute is placed before us. If one considers the report as a whole, it is very negative for the writ petitioner. Full stop. It opines that pregnancy above the age of 35 years is high risk. Full stop. There is higher risk between the ages of 40 and 60 years, especially of thromboembolism, and that women older than 35 years contribute to 31% of death arising out of pregnancy. Learned counsel for the state has shown us a judgment of a division bench of the Kerala High Court, so-and-so versus so-and-so, decided on 6th August 2024, where the vires of the said section of the Act has been upheld, and by its final order, the division bench has disallowed the procedure to be performed on a person who is above the age bar. Paragraph. We think that this matter needs a more detailed consideration. Paragraph. The writ petitioner, the state and the central government are given an opportunity to deal with the affidavit filed by the institute. Such affidavits may be filed by March 13th, as we view some urgency in the matter. Paragraph. Our tentative view at this point of time is this. Paragraph. If the Act has permitted this procedure to be performed on a woman of 1 day short of 50 years of age, subject to normal or special risks that a particular patient may be exposed to, it needs detailed explanation as to how, after 1 year or so, the procedure will become imminently dangerous for a particular woman and cannot be performed. Full stop. A better answer would be that the risk should be evaluated patient-wise. Full stop. Our views are tentative, subject to full consideration during hearing of the writ. In the meantime, an interim order of the Calcutta High Court in WPA 1592 of 2023, Ashwati Mohri and others versus Union of India and others. Can be very conveniently employed in case the writ petitioner ultimately succeeds in this writ. Paragraph. The procedure to be undergone by the writ petitioner, as explained by her learned counsel, is that the sperm of her husband and the embryo, where is it in the writ petition?
My lord, page number 4, paragraph 4.
You tell us, read.
My lord, it says the IVF is a process where an egg is combined with the sperm outside the body and the resulting embryo is
All right. The egg of the writ petitioner would be combined with the sperm of the husband outside the body, and thereafter,
and the resulting embryo is transferred to the uterus.
and the resulting embryo will be transferred to the uterus. Paragraph. As far as the procedure outside the human body is concerned, there does not appear to be any problem whatsoever. Full stop. That procedure has been permitted by the interim order of the Calcutta High Court on the following terms. Page 18 of the order, red, marked in red. Paragraph. Therefore, the procedure, therefore, as an interim order, we direct the procedure which is performed outside the human body to be started and await. Full stop. The final procedure is to await the result of the writ. List this writ for hearing on 25th March.
Obliged.
Item number 3 to 13.
Yes.
May it please your lordship. Your lordship, this is a writ appeal filed by the state, your lordship.
Yes.
This is a writ appeal filed by the state, your lordship. So I'm praying for some more time, your lordship, in this matter, if this matter may come after 2 weeks, as the leading counsel is not available today, your lordship.
Ready for hearing?
It's ready for hearing, your lordship. So I'm praying for some time for today.
I'm for the appellant, your lordship. She's seeking for accommodation on the ground that the senior counsel is not available today, your lordship.
You took adjournment on 26th February.
Yes, your lordship.
Then
May your lordship grant us some more time, your lordship, in this matter,
why?
as the leading counsel is not available today, your lordship. The leading counsel is not available today, your lordship.
Where is he?
He have some personal difficulties, your lordship. He couldn't come today.
Tomorrow?
Okay, your lordship. Yes, your lordship.
What do you say?
Lordship, yes. Not tomorrow, your lordship. If lordship,
How many matters are there tomorrow?
Please, sir.
Huh?
3 and with Justice
All right.
Bhattacharya.
On the prayer of learned counsel for the respondents,
Respondent, Your Lordship.
respondent. These appeals are adjourned for the day. Kindly do the matters. Don't seek adjournment all the time.
Comes on 6, Your Lordship.
What?
On 6.
Why? Tomorrow you're going out on an
No, I'm
excursion.
No, I'm here only, Your Lordship. I'm here only, Your Lordship. Only, Your Lordship, some fixed matter are there before the Honorable Single Judge, Your Lordship. If I mean,
We always thought the division bench, particularly chief.
Lordship, yes,
priority over all
first preference will be the
all
TV
at 6.
on 6. I'm highly obliged, Your Lordship. Highly obliged, Your Lordship.
Adjourned.
Much obliged, Your Lordship.